Four arguments in this speech. Firstly, on the balance of power. Precedent and interpretation means that power is dispersed between the judiciary and the legislators. Why is this? Because precedent is harder for individual legislators to overturn. So if the president wins an election, for instance, he can't just then say that future elections are void. Secondly, it's often based on documentation. For instance, in Canada, we have the Canadian Charter of Rights and Freedoms that offers lots of protections, for instance, on free speech, for instance, on human rights, for instance, on language rights for Quebec. And I would posit the vast majority of these protections that exist within constitutions are quite good, right? Because they involve fundamental human rights that haven't quite changed over the last 200 years. And even if, you might get some bad judges some of the time, I think oftentimes the reason that you had bad judges in the first place was because there were politicians there to appoint them or otherwise influence them, in which case they cannot then argue in opposition that the politicians will be much better. That symmetricizes them already. But I would further posit that in many instances, even bad politicians are able to get checked by these judges. For instance, when Trump contested the election, the Georgia courts denied his claim, and the reason they did that was on the basis of precedent of the last 250 years of American democracy. Finally, I would posit that courts often have legitimacy, and when the government is the only body that has a claim to political legitimacy and legislative legitimacy, I think that is when people are able to control their country in terrible ways, and you empower demagogues. As opposed to when courts have a legitimacy claim that is seen in the public eye as a legitimate thing, I think that is when it is much easier to get a balance of power in the public optics as well. Why is this important? Firstly, because the worst harms the opposition need to defend are things like democratic backsliding and demagoguery. I would posit that we get substantially less of that because we stabilize the extent to which legislation can be changed and stabilize the extent to which rights can be infringed. Secondly, I would posit people have far less fear, that even if you know that the laws are somewhat draconian in your country, you know that they cannot possibly, that they are very unlikely to get worse. And I think that gives you a sense of stability and allows you to plan out your life in a way that is important. I would weigh here that stability is far more important of maintaining those basic rights, because it is from those basic rights that the rest of them are able to flow. When you have free speech, you can go out and protest the government. When you don't have free speech, it is much harder to hold them to account. And I would posit, moreover, that insofar as they defend a more democratic system in which legislators have some degree, more influence, I would posit it is impossible for them to defend that the decisions that democracies make are perfect. In many instances, they're not. In many instances, they're actually quite bad. And I think we see recently with trends of, for instance, right-wing populism, that a lot of these trends are actually ends up harming minorities in favor of a majoritarian basis. Let's talk secondly about adaptability. Legislation is often ambiguous. Because legislation is ambiguous, you require a court in order to have substantial degrees of interpretation in order to do this. Why is legislation ambiguous? Firstly, because facts on the ground often change. Let's say you're doing environmental regulation. The environmental regulation is contingent on the technologies and other capacities that you have at the current point in time, which change over time, even year by year basis. The problem with this is that when you don't give courts the ability to interpret these laws, it is far harder for them to actually adapt these laws to the time. And parliaments often find it hard to constantly update these laws as well, because they have capacity constraints. There's limited legislative time. Secondly, because there are political constraints, because you need to have enough people agreeing in order to pass these laws in a way that is suboptimal. Thirdly, I think there are often filibusters, which mean that these systems collapse entirely. That even if most of the people would like a law passed on environmental regulation, for instance, the political climate of that country is too toxic in order to get anything passed. And I would posit they have to accept the risk that in democracies, this often happens. It happens for months at a time. That is a significant problem for them. Therefore, what common law provides is a wider range of interpretations versus the inflexibility of civil law. And this may seem minor, but I think it is necessary for the function of democracy that these laws are able to get passed, but that these laws are actually able to get used as well in the way that they need to. I think when you have ambiguities in legislation, you block that law from actually doing anything useful in the world or being used in its obviously intended purpose. If the interpretation of the courts on some technical matter differs from that of the legislature, they're able to then pass a new law to modify that. I think that's perfectly legitimate for them to do, but in many instances they are unable to do. They just the fact that the courts have set this up means that oftentimes these are good interpretations and they're not going to do that. Let's talk thirdly about predictability. Common law is much stricter on basic issues, specifically on property and markets. They say, for instance, that you cannot seize a private property. They say, for instance, that there is some degree of free market legislation that exists either from a constitutional basis or because that is what past precedent has decided. And that is a precondition for investors to invest, particularly in the developing world, because then they know that when the president changes in a country, they're not going to have their property expropriated, even if the president may try. I think that gives them an additional sense of stability and security that is a necessary precondition for wealth to be maintained. Closing.
I voted to my politician because I wanted to have abortion rights. Then all of a sudden 12 white men said, oh no, you can't abort your child. How do I have more trust in that system now?
People voted for Trump because he was going to remove the abortion rights. Then Trump put the people in the office, and then the Supreme Court justices decided, right? That's the timeline we're all on, right? The consequence of this is that the preemption I had just stated, which is that the bad judges come from bad politicians, means they cannot then say that bad judges are used in order to overturn the bad judges are like worse than the bad politicians put them in office in the first place. Back to predictability then. I think it's important because you allow investment to occur in the first place. I think you allow people to stay in their countries instead of leaving due to the uncertainty, and that is important particularly for economic development. Finally then, on judge involvement. Why is it that judge involvement, particularly in criminal cases, but civil as well, is not good? Because they're not impartial. When you get into the weeds of the case, when you know the victim's name and you've met them months before the case, when you know the perpetrators, when you've seen the crime scene and you've seen the evidence, I think this puts you in a particularly emotional state. And that emotional state might be fine if all we were doing was sentencing, but common law systems allow judges to go and do these things during sentencing. Instead, this is about the truth. This is about the ruling itself that is delivered. And I think for the truth to be delivered, what is required is impartiality. On their side of the house, what you often get, instead of impartiality, is the judges empathizing with particular people, or seeing a particular place and getting preconceived notions of what that looks like, or what that is, or how the crime must have been committed. And the consequence of this is that it is impossible to adjudicate impartially. Why is it then that this is they might say, well, you have bad defense attorneys and judges correct for this. 3 responses. Firstly, because oftentimes judges and prosecutors end up in very special and close relationships with one another. So in Japan, for instance, we know this happens because, structurally speaking, prosecutors have much closer contact with judges over long periods of time, and when prosecutors are the ones showing the judges the place where the crime happened, when prosecutors are the ones working with judges constantly over months, not just in the formality and stuffiness of a court system, but outside of that as well, I think that is actually when you get far worse prosecutorial imbalances. But moreover, I would posit many of the cases that have bad defense attorneys don't go to trial in the first place, they get plea bargained out. And thirdly, some of the most consequential cases, the cases that affect everyone, the cases that are about the legislation that is passed, the cases that are about the human rights that we protect, are not things that involve bad defense attorneys, but rather good defense attorneys on each side, arguments that can be balanced and weighed off by experienced judges. We're very proud of those.
I'm sorry, what the fuck have I just heard? Opening government literally says that individuals vote people into power because of the preferences that they have, and it's okay to undermine those preferences. The very individuals who desire the law to be applied to them in a particular way, the violence that is inflicted on them by governments, is now being done in the hands of random individuals who have never been voted in. Opening government is absolutely insane. But 2 arguments on the actually practical things. First, for the most visceral rights, 4 responses. 1, often these are things ingrained in the Constitution, which means these are the very foundations of the way in which the country works. Things like the ability to have free speech or freedom of religion. So it's unlikely that this is the debate. Secondly, often you have visceral backlash to populism in its intense form, which means it's likely that there's democratic checks and balances in the way that opening government is unable to get. Thirdly, it is much easier to corrupt a judiciary when there's only 12 people in the power, where you're able to bribe these individuals. So I think in the worst instances, it's much easier for populists and demagogues to be able to overcome that. But fourthly, when the harm happens for the most visceral rights, on their side, it's irreversible, because it is fundamentally in precedent forever. On our side of the house, it can be changed, it can be dynamic, it can change the way in which prior precedent is not something that happens to such a large extent. That's broadly why I think this is not part of the debate, but even if it is, when the worst harms happen, they're long-term on their side. Secondly, in terms of investment, like guys, just look at the countries in the info slide. France and Germany are failing fucking countries. They probably have some amount of investment as well. There's probably a bunch of other exogenous factors. I'm genuinely unsure why this is the debate. Three arguments from opening opposition. One, on a principle as to why civil law better represents people's preferences. Second, as to why they are likely to be more dynamic. And thirdly, about why common law perpetuates inequality. First, civil law is literally just government good because government implements legislation that people's preferences actually want. At the point in which, in the majority of cases that are put in the info side, these are democracies with high levels of representation, you're likely to have the accurate aggregation of preferences. The way in which people want the violence, monopoly of violence of the state to be discharged on individuals. It is the way in which you want policing to occur. It is the way in which you want the kinds of criminal punishments to occur for particular crimes. This is important because you have no other recourse to the state. You have no other ability to be able to say what is good or what is bad other than the way in which the state inflicts its power upon you. Given you are in such a vulnerable position, it is imperative that you have the ability to be able to access this. Two things on weighing. One, this is comparative, which means even if we don't prove that everyone is better off on our side of the house, it is still preferable that it's on our side of the house because on their side, you don't vote in the judiciary, you don't vote in people in power. But secondly, I would argue that judges are actively not a cross-section of the population, but rather ones those who are the elite. Firstly, because it's extremely expensive to get a law degree. It's like 6 fucking years of pain. I'm unsure as to why the average individual who is particularly lower income is able to access that to an extremely large degree. But secondly, often the individuals who get to the very top are subject to massive glass ceiling issues. There's very few black people at the very top of the judicial system. I think that it's very unlikely that on their side of the house they're able to get an accurate cross-section of the population. But secondly, even if they are, they're not accountable. On their side of the house, these judges are in there for life. They're unlikely to ever face backlash for the kinds of decisions they're likely to make. On our side, governments, even when they fuck up, in the worst instances, are able to access some degree of accountability. They're voted out in the instance in which they're unable to provide policies that actually represent people's preferences. I think that even in the instance in which we aren't as accurate, we're able to change the way in which we realize that laws have not worked in the past. I think, therefore, the principle weighing is simple. The state takes away your rights, and it is imperative that you have some say in the way in which it discharges its most heinous monopoly of violence upon you. The ability to put you into prison, the ability to take away your property, the ability to take away your freedom of movement. Given these are such visceral and important implications for you, we think you ought to have a say in the way in which it works. Secondly, why is common law unlikely to be dynamic? Before I go on, Uzair.
I know OG mostly talks about Supreme Courts, but we do need to broaden the case about all of the courts and how they interpret the law as well.
Okay, I mean, like, I'm not sure why the principle doesn't still apply. Like, I'm sure you'll have an extension, which won't make much sense. Okay, why is it unlikely that common law is like to be dynamic? I think there's two reasons. One, the barrier to make precedents is relatively quite high. Given that you have a vast amount of legal literature that exists in the past, it is just unlikely that you're going to be able to break precedent in the vast majority of instances, because you have to consider what the long-run implications of these kinds of things are, which means it's unlikely that you're going to do this in the vast majority of instances, even when the trends and preferences of the people have broadly changed. I think this means that either you don't break precedents at all, or B, there is a massive time lag between when you know that it's very, very safe to be able to break these precedents, but that in the short run, you have a vast amount of legal legislation that is not done in a way that is actually good for the individuals or what the individuals want. But secondly, as I've already explained, judges are old, they're white, they're unlikely to be in touch with people at the bottom. They're unlikely to be actually able to be dynamic because they're stuck up in the old values that they've been taught. It's like economists who still think about neoclassicism and don't actually understand that the world doesn't work like that. I think that broadly, given that people are ingrained in the way in which they've been taught, ingrained in the way in which they've been brought up, it is unlikely that on their side of the house, this is likely to be particularly dynamic. Why is then dynamicity good in the way in which it naturally occurs? In other words, why are trends positive? There's 4 reasons. First, preferences, I think, at the very beginning are just something important. So even if we don't prove this, it is just principally good that preferences are respected. If it is genuinely the case that individuals want to have no abortion rights, we think that's perfectly legitimate in the way in which it works. But I think there's 3 reasons as to why trends are likely to be good. 1, there's decreasing influence of things like tradition, things like religion, at the point in which it's significantly more likely that people are educated and have more understanding of different factors in the way in which the world works, which means it's less likely that you have dogmatic views being imposed upon you. Secondly, you have more accessibility to different cultures. The internet, massive improvements in technology, means you're more likely to be able to access other people's experiences. But thirdly, I think the rise of living standards just means that people tend towards more understanding of other people because it's less us versus them mentality, which means it's more likely that you're able to access better trends on our side of the house. Dynamicity then means on our side that trends of legislation go towards individuals in terms of protecting them and not the democratic backsliding that they talked to you about. Lastly, in terms of perpetuating inequality, there's two reasons for this. First, lawyers usually charge extremely high fees. Given the importance of that on opening government, it is likely that poorer individuals are unable to access this. This deals with municipal courts in Uzer's case as well, because it is likely that in those instances, whatever that case is, it is likely that in those instances, these individuals are still structurally fucked over, given that they have less monetary capacity to be able to finance the most prominent lawyers, and also this means that given that legal doctrine is something that is extremely hard and expensive to be able to research, you need a lot of interns, you need a lot of people working in slave labor. I think it's just really likely that this is something that's extremely important. I think then, in contrast, civil law is truth-based, because judges have an incentive to go out and search for the evidence as well, rather than impartially being okay with judges or lawyers just providing certain evidence. They might hide evidence, they might not be equipped enough to be able to find all the evidence, which means it's just less likely that on their side of the house, you're actually able to access the truth. Vote OO.
There are good people and then there are fucked up people. Let's start with the good people. And here I want to talk about the idea of uncontroversial good intent. Because it's possible that courts actually want to get to the truth and that parliaments want to set good laws, as they do in most countries around the world. But sometimes legislation can't account for the nuances of the real world. When you are a parliamentarian in a 100-seat parliament, going through like every single piece of policy and law that will affect the country for the next 4, 8, 10 years, you can account for whether you protected everybody's constitutional rights or not. And this is not a malicious thing. Because of the fact that you just have no time or basis, or you have blind spots the way that they had a blind spot in their case, to figure out that everything cannot be perfect. And that's when the courts come in, right? Because when laws can sometimes violate constitutional rights, that's where precedence is important. And that's where we need the specific lawyer to look at the specific case and be the only one in the fucking country that cares about whether that individual who's being affected the most profoundly can have their rights protected or not. So in the case of uncontroversial good intention, we win because their side is reliant on a system where 100 people can get laws right for every person in the country. That's impossible. But okay, let's talk about malicious intention. And here, I want to talk about abortion rights. The first thing I'll point out is that it's harder to just randomly overturn precedents the way it is easier to randomly overturn laws. The first reason is the evidentiary burden is higher. That is to say, you probably need significantly more evidence to show why precedents from the past was not something that should be followed today. It takes a longer time because you don't just need a simple majority to agree with you in the parliament and Johnson goes, "Hi, let's vote. Nay, we got it." That's not how it works in the courts. It only works in parliament. What does this mean for their case? It meant that for 45 years, Roe v. Wade stood. It stood during the wave of liberalism because courts at that point found that it was a constitutional violation of a woman's right to autonomy. It stood through Reagan. It stood through Bush. And that's extremely important because on their side, you will have 8 years of abortion, 8 years of no abortion, 8 years of abortion, 8 years of no abortion. The difference here is, yes, it's been overturned today, but there's two things I want to point out. One, the fact is that insofar as we know that this could be unconstitutional, there is a chance to do this again in the future anyway. But two, local courts can still enforce some protections for people on the ground. So, insofar as on their side of the house, you have to follow the laws that white Republicans set up no matter what. Local courts have no ability to protect individuals on the ground anyway. Let's talk about preference access. They say the most important principle in this debate is that you must be able to access your preferences. But in voting, you don't just decide your own preferences. You decide what somebody else has to do with their life, even if it doesn't affect yours. You as a man have a lesser value placed on the rights of women to abortion, yet your vote counts exactly the same as the vote of somebody who is a woman, who is affected by this policy in the first place. Should it? Probably not. But that's how democracy works. And that's why we need balance of power. Because the balance of power suggests that some people's rights matter more than just your fucking preference. And I think that's key the distinction here, insofar as you vote on your issues and you want to protect your own rights. That's absolutely fine, but somebody has to be there to look out for the minority. If only Parliament is going to do it, and Parliament is a majoritarian system, nobody is looking out for the minority on their side of the house. That is why we have balance of power in the first place. But let's just say, right, we live in a fucking dystopia. Supreme Court very bad, Trump appointed 6 white people, all that shit, right? I have 4 methods of redress. The first is, if you really think that the courts are so terrible, there are mechanisms of reform for the court system itself. That is to say, most systems of governance in common law societies have less charged political processes for judges. Let me give you a few neutral ways in which you can reduce the ability for judges to make such to be tied into specific politicians and tied into specific ideologies and to actually be impartial in nature. 1, you can have term limits for judges. 2, you can have a system where you can challenge a decision in other courts or in higher courts. These are all methods of redress that exist, that Parliament can set up on their side of the house to protect minority rights without fucking over the interests of the majority. So if you really do believe that preferences matter, but you also believe in an impartial court, you have to go with outside the house, because there are methods of redress. Maybe they're not done in the US, but they are done in many parts of the world where this debate still fucking takes place anyway. And even if you don't believe this, the reality is that it can be done, and like parliaments have incentives to do this, because obviously the fact that people feel that their rights are protected by the court will make you win the next election to begin with, which is why legal reform usually is very popular. Closing.
So specifically, to not make it easy to hurt minorities, the legislation process is very difficult. This is a feature, not a bug.
No, it's not difficult at all. It's much hard because you don't need evidence. You just need some people to be like, I agree because my constituents agree. That's all you need. There's no evidence, there's no arguments, there's no logic. It's just who fucking agrees with who ideologically. You know this, you can gut check this. I'm not going to spend another minute fucking proving it to you. But they didn't even talk about the second half of the debate, the investigative process. And here they said, suddenly, case shift. Lawyers, they're all truth-based. White, truth-based people. And I think that's the problem with their case, right? Ultimately, it relies on the intention where lawyers are really good and really bad at the same time. What we told you was this. At the end of the day, if you look at civil law systems, the judge needs to work a lot more with the prosecutor. They have special relationships with the prosecutor because they are also going down there to collect evidence. They are also going down there to see what happened on the case. They prejudice themselves before any decision is already made, not because of bad intention, because the system is structurally created in a way that allows it to happen. So if you want the right to a fair trial, if you want people to be able to access basic rights that their side and the majority of people on their side do not care about, but really do matter to minorities, you can only vote O3.
Panel ready? I'd rather have my vote be 1 in a million than everyone's collective preferences on the law that governs our lives becoming second to the 12 richest graduates from Harvard Law School. Why should their assessment on where we should apply moral parameters outweigh all of our own? They never respond to the illegitimacy of having our judicial system governed by this elite that's unable to represent the way in which we want our law to be enforced. We told you from the beginning that morality is highly subjective. Firstly, it is tethered to time and place. If you're born in the 1950s, like the people on the Supreme Court, or the 2000s like the people in this room. If you lived in Germany or in China, all of these things influence A, the moral norm you set as a baseline to inform and calibrate your own moral decisions, but B, the feedback loop through which you develop and adjust your morality. If I say abortion good in Texas, then everyone's going to ostracize me, and I won't like that. But if it's in another state, people call me a woke queen, and then I feel really socially desired and validated. All of these things shape the way we come to decisions. But secondly, it's subjective because we don't have epistemic access to other people's experiences. We cannot come to a fully informed decision, and even if we are fully informed, we still weigh this differently. Therefore, I can come to my own moral assessment, but I cannot impose my own moral assessment onto someone else. Given each individual's moral is subjective, the only legitimate way to set the moral outcomes in the judicial system is to aggregate people's preferences to account for all of these subjective individual morals. On GovBench, these judges do not represent the aggregate. Firstly, because they're a small group that does not encompass the range of experiences. That means there are lines of epistemology and experiences that are not going to be represented. But secondly, this specific group is not at all proximate to most people's experiences, meaning the inference, even if you fundamentally and epistemically cannot access it, you still are not able to come to a close outcome. A, Aniket told you they have a very privileged outcome. It takes a lot of money to invest in this academic resources and opportunities and have stability to go through something as rigorous as law. But B, even if it didn't, you still ended up in those elite bubbles even if you had that bad upbringing, right? You still ended up in law school, in law internships. You had the social interactions dictated by people who, for a majority, did have these. But, note, it's difficult for them to approximate values that deviate so far from their own framework, and therefore is really unrepresentative. Judges hold a lot of power. They can take your bodily autonomy away by locking you in prison. They can take your property away in the reparation fees they set. In many areas, they can sentence you to death. Given they wield such dominating power over you and your basic rights, we should set a tighter boundary on the way in which they use this. On our side, you as the people on the ground get to assess where those boundaries are, because these judges are bound to interpret the law by the way that you say. On their side, judges have significantly more leeway to dismiss your opinion or to decide for themselves which outcome is best, with little accountability here. I think there's really important weighing. Firstly, even if OG fully proves they're practical, if this is what people voted for, then that's a legitimate preference. We explained to you that morality is subjective. It used to be the case that most people would agree with you that slavery is good. Now that's something that we think is bad. So if the things that opening government says are bad, who are we to then say that this is something that's bad? And most of the people that are okay with going for the civil system despite these outcomes happening. But secondly, the way common law violates your self-determination is worse than all of the harms on OG, because to be stripped of your basic ability to have some degree of accountability in the one monopoly of violence power that threatens you and all your others sequential rights stemming from that autonomy is a worse violation than the things that opening government said, given A, it is the prerequisite towards your ability to unlock these other things, but B, you are never able to opt out of these circumstances on their side, whereas on our side you have accountability mechanisms like voting in a different government if you don't like these outcomes, or reverting to a different system. We told you that the legal system is fundamentally inequitable on GovBench. I know this responds to their things about minority rights and stuff, right? Firstly, common law allows us to allow a select group of privileged elite to receive power to change the enactment of the law that people on themselves voted for. I think on our side, civil law comparatively more encompasses the types of rights that opening government says that they're able to do through these systems. Because firstly, I think the majority of people are more closer and proximate to the experiences of these vulnerable stakeholders they talk about than the privileged elite judges for the analysis that Aniket gives you. But secondly, even if it isn't the case, I think it's valid. It's invalid. But also, I think we flip this, right? Because on Gov, there's more inequality within the procedure to which you get to these outcomes. If you can't afford a good lawyer, nobody identifies the law that works in your favor or actually shows that you are right. Nobody asks about relevant information that your short-staffed pro bono lawyer missed. On our side, the judge helps as an investigative mediator. On their side, that process itself is rigged. So even if they show it is possible you get to good outcomes on their side, it is not probable because the people who instigate those cogs in that system are not the people with the incentive structure that Aniket has analyzed to you. Then they say, you're going to have a balance of power on their side, but not on ours. But know that firstly, there's checks and balances exist on our side too, through constitutions and stuff. These things don't go away. The things that they say are merely an enforcement, but it's unclear why that enforcement needs to happen in a highly subjective way that isn't bound to existing rules. Legislators already have built-in accountability mechanisms when people can go to the voting booth. Judicials, I think, are more OP on their side versus governments on our side. They're subject to more accountability. Closing.
What about juries?
What?
What about juries?
Jury?
Juries.
These exist on either side, right? But also note that juries are different because you still are selecting them from the subset of the population. You don't have the same filter mechanism going into it because what socioeconomic status you have doesn't decide whether you're put on a jury panel. That's a random selection. On their side, the judges that decide are set by a set of criteria like how much money you have, how much stability you have, which academia you reach. So I don't think this is comparative. Then, opening government talks about democratic backsliding. But I think the opposite is true, right? Because common law is not an old dynamic. Judges are really old. All but one of the US Supreme Court judges were alive when France administered its last guillotine. That's a very different frame of reference than us living today. You must go through this process. But B, it is very stigmatized to rule against precedent or set contradictory precedent. Know that there is an us versus them mentality in these arbitrators of justice. You protect each other. Going against this is not just disrespects the judge who set the precedent that everyone glorifies when they study them in law school, but it also disrespects each additional judge who has ruled on that set precedent. That means over time it becomes more and more enshrined because more and more judges have bought into that existing precedent and made rulings based on that. That means you lock these decisions in because they become harder and harder to change. You subject people now to decisions that were made long before they were born with very little ability to actually opt out of those decisions. On our side, we have an opt-out mechanism, meaning even in our worst case, where we still have the harms that opening government talks about, we have a better ability to opt out and get it away. Whereas, if the harms we talk about in opening government are true, they have a less mechanism to opt out and take that away. Then they say there's going to be a case-by-case basis. I already explained to you that breaking precedents is really hard, so this is unlikely to encompass all the individual circumstances of the case. But the prerequisite to that is that you have all the information within the court, which is unlikely when you have two biased lawyers versus a judge who is still able to investigate. So no, we prove the prerequisite and the capacity here. But secondly, the inequality means that people are more screwed over, right? For example, people that are poor. Firstly, their case about minorities doesn't really work in this way. But secondly, these judges do not represent the proximate preferences of said minorities. We explain why the people within the system are more able to encompass those beliefs. For that reason, vote OO.
Ready when you are. Okay, 3, 2, 1, start. There is significant tension in the case that opening opposition brings to you today, because all of their analysis on the bias of judges and why this is so incredibly bad in the civil law system would equally and to an amplified degree apply in a common law system, would even more apply in the civil law system. Why is this the case? Because basically they're telling us that these sorts of biases, the old white men, etc., assuming that is true, then they would lead to a sort of biased outcome on this side of the house. Note that in a civil law system, and the judges are basically the same people on both sides of the house, they presumably also have these biases. Now they're perhaps less able to express these biases in the precedent that they set, but they're more able to express these biases in the investigation that they do, in the way they lead the proceedings, in the extent to which they believe different forms of evidence, in the extent to which they decide to follow one or the other lead more or less, meaning that at the point at which biases exist, there's absolutely no reason to assume that opening opposition would actually have less of it on their side, and in fact that it would harm people less on their side. Note that continuing this, it is actually more difficult to call out biased judges on their side of the house because the judge can always quote the letter of the law, and the way they applied their bias is much more subtle because it is very, very difficult to prove that a judge just didn't see case exhibit 27 and then ignored that in their proceeding, as opposed to them writing a ruling based on the constitution of the country, which is obviously biased to one or the other side. We think on our side of the house, we're able to call this out, and note that if a precedent is called out, like there are mechanisms by which this precedent could be overturned. They themselves talk about Roe v. Wade. There are many cases in American and other history where a precedent changes as the social structure of society changes over time. Some extraneous rebuttal. Firstly, in the case of not finding good representation on their side of the house. Note that especially in cases that are likely to set a precedent, advocacy and pro bono groups are incredibly likely to pay for extremely powerful judges, extremely powerful lawyers in order to make the precedent go in their interest. Like Black Lives Matter and similar groups pay for excellent lawyers for given cases in order to try to make the system more equitable. And finally, we don't think the burden on side government is to defend a system where Supreme Court members are appointed for life, but instead like the overall nature of this debate. Now let's talk about why the common law system is so much more within the core ideology of the state. Why is this the case? In any case, in any instance where there's ambiguity in a case, where it's not entirely clear, given the changing nature of society, how to adjudicate it, on our side of the house, the court necessarily needs to look to the higher principles that govern the state overall, and then derive the logic of the ruling from these higher principles. These higher principles are like the basic constitution, the common law, whatever the guiding and founding document of a given nation is. And note that this is much, much better than side opposition for three specific reasons. Firstly, it is more legitimate. Citizens buy into the state not on the 5,000 pages of the Bürgerliches Gesetzbuch or some shit, but on the basis of their understanding of the principles that guide that state. I buy into a state because it is democratic, because it grants me certain rights, not because of a specific law that might apply in a specific case. Therefore, if the court enacts power over me by the logic of the buy-in in the state, this is fundamentally more legitimate in enacting power over me than some specific law that I don't even know of at the time of which I'm bringing it. Secondly, the buy-in. Following from the first point, individuals have more buy-in in the system. They trust the legal system more, they trust the government more when they can understand the logic of the proceedings and the way they are written. And thirdly, it is fairer because individual case-by-case laws often deal with incredibly ethically similar cases, like similar theft is theft, whether it is like a digital theft or physical theft. But physical theft laws were written like in the 1500s, and digital theft laws, if they even exist, they were written in the 2000s, meaning that they're likely extremely different, even though the underlying morality of this is the same. We believe it is much more just to appeal to the core tenets of the state and then apply equal justice in those cases.
Right.
Yes?
Even if bias is indeed symmetric on either side, its intensity of harm is much greater on gov because it's long run. On our side, it is not codified in precedent that lasts a century but can be overturned in government.
Okay, that's simply not true because if a given legal precedent is it only exists in a case of ambiguity, right? That sets a legal precedent. Meaning that if this is an incredibly high profile and important case, then the government can enact legislation to counter this legal precedent. For instance, a democratic president, House, and Senate in the US could specifically legalize abortion in the United States if it is indeed the will of the populace. But let's talk a little bit about the principal right to an advocate defender as opposed to a non-advocate defender. Note that the state has incredible power over you, right? The state can force you to, they can accuse you of something, force you to come to court, steal your time, waste your time in many cases, and then deprive you, if they find you guilty, of your liberty, your agency, your autonomy, and your dignity, especially if you're innocent. Now, under the civil law system, you are only entitled to a neutral, information presenting lawyer, and it is up to the biases and the power of the state solely to decide what happens to you. Uniquely on our side of the house, the fundamental right to self-defense is upheld because a lawyer that acts specifically and biasedly in your interest is your way to defending yourself against the immense power of the state on our side of the house, giving you more control over your outcomes and more agency, which is an incredibly important thing. But finally, note that there are 300 parliamentarians and staff, so perhaps 1,000 persons in Parliament. They have daily duties, they have new laws to add, they have campaigns and re-elections and things like that to do, and then you expect them to review outdated laws in a changing world where sentiments and moralities change, where public displays of affection and drug use were outlawed just a few years ago and now are changing. Then there are technical changes like digital crime, copyright, streaming, etc., economic changes, globalization, business, etc. An incredible amount of detailed information changes over time, and there's just a rate-limiting factor necessarily in the best of all possible parliaments to adequately deal with this. Now, only if the individual thousands and thousands of courts on the ground have the flexibility to react to changing society themselves can you actually live in the 21st century and not in the 1850s when most of our civil law books were actually written. We want to live now, not in the past. Vote closing.
I'd like to
No. We think that the basic principle of not going into prison when you're not guilty and sending guilty people to prison so they won't actually harm other people is the most important principle in this debate, and this is how we're going to win. Let's start with some rebuttals to what we get from CG. They tell me about, I buy into the principle of the state. Where is the button of bind? I'm not sure because I didn't buy into the Israeli one, but never mind. I'm really unsure why the judge has the same principle of state that I have. Like, really, this judge has been brought mainly by Harvard, Yale, and things like that into a very specific principle of state. But notice much more. The logic of the proceedings, like, what does this even mean? Like, what does this mean? Look, the average thing is literally theft, is literally murder. What is the principle of state here? Why do you need to interpret the laws? And then he gives us about the digital theft. I'm really unsure why you have a lot of digital theft before a parliament can legislate that. Yes, like one time it happens, you see that there isn't a law, you legislate, but they tell us, parliament doesn't have time. What? Why? I'm really unsure. Like, take more staffers to do that. Like, not everyone needs to know a lot about that, but Parliament has an incentive to actually do a good law. Why does Parliament know it better than a judge? Because it has the people who are actually experts in digital things, people like me, for example, who can actually tell them how to do a good law and not depend on a judge who has a lot of cases, who is 55 years old, who doesn't know how to type with more than one finger, deciding according to the principle of the state. What does this mean to actually do any digital theft? That means that we have a better laws that are actually accountable to anything like that. And they tell us about the defense against the state that is being, they tell us about, look, the state that is so strong. I'm really unsure. I think, let's flip this, okay? The state is stronger on their side of the house because there the state is always showing the cases. There the prosecutors that get more money than the defenders are able to actually push forward. On our side of the house, the judge is there to actually do that, to protect against the state showing its case in a biased way. Therefore, we flip that, pulling the burden on them. Let's start in our case. Firstly, better decisions for a better decision in terms of justice and truth. What happens on our side or on their side of the house? Several things. Firstly, on their side of the house, judges can ask the people testifying anything, and this is crucial because they're the ones taking the decisions, and the juries are, and they're the ones that are likely also messed to ability to understand the juries and they have most time with them, etc. But even if the juries are there and they don't understand them, they're the ones giving the amount of sentence. The ability to know that means that they can answer their own questions, which are sometimes different than the ones that the prosecutions and the defense have. Because the prosecution and defense don't have the access to the judge and know what interests him. Many times the judge wants and thinks other things about, for example, what was the mental state and how did the discussion with the sister of the victim go 1 week before that, and he thinks that this is crucial for understanding this. The ability to understand these things and to ask specifically the people testifying that means that they're likely to actually get a better understanding of what the right sentence is and not to get a random sentence. Secondly, judges can ask for more evidence. I can stress enough why it is important. On their side of the house, it takes a long time, and only after prosecution has all the evidence, the sentence starts. On our side of the house, it starts almost after the crime, and the judge can always ask for more evidence. defense cannot ask for more evidence. They can say, it's not there. But other than discovery, they cannot tell the police, you need to get into that house now and actually get the things because this is the warrant. They cannot tell them, look, I want this person detained at the airport, and the ability of the judge to also say to the police, you can't tell me you don't know because I am literally in charge of that investigation as the inquisitorial judge. This is crucial because it means that we can actually prevent miscarriage of justice because notice, even if police are good, which I think we can agree is not very much likely, if you think that they many times have the incentive to prosecute, to succeed, so they hide evidence that isn't good. The defense can say they hide it, but we can't bring the evidence that shows that it actually shows that the other side is unlikely to be guilty in these cases. Lastly, many times because the sentence is much later because all evidence is there, even if you ask for evidence, the evidence isn't more there. The phone records are already deleted, etc., because the sentence is done much later after all the evidence is collected. This is crucial because the decision of juries and judges in these cases is much better. The ability to know if a crime has been committed, if a murder, means that we get so many people not in prison and others are in prison for that. That means police does better work because it understands that it needs to do an actual prosecution, brings all the evidence forward, so we don't get the first one that looks black and was near the murders, but actually the one that murdered the little girl. Before I move on, I will take first.
The questions that judges ask are determined by their close relationship with the prosecution and emotional connection with the victim. This is why 98% of defendants get declared guilty in Japan.
Thank you. No, I think that there are other problems in Japan, maybe the societal view of that. I don't want to get into that, but I think everyone knows Japan has problems. Secondly, I think that it's important to know that is not the case. I don't think that prosecutions and judges have such a close connection. I think that many times they have just symmetrically connections with the defense lawyers that are public defense lawyers. In these cases, we think that judges just have a huge burden to feel that they will non-guilty, like just sentence. Let's move on to testifiers and witnesses. Why are witnesses going through a really hard process on their side of the house? There is incentive of defense lawyers to show himself as strong to his clients. Many times the will of the client to show that he's attacking the other witnesses. Because it's the incentive of the prosecutor and defense to be famous for being aggressive, thus deterring people from testifying in other sentences. Because many times a jury system, it's just many times when you say that someone was unfaithful to his wife, etc., it's very easy to paint them in a dark picture. And lastly, because specifically there is incentive to bring the worst memories to people in order for their testimony to go bad, to make them cry, to make them aggressive towards so they're less reliable. Why justice can't stop it on their side of the house? Because that's the tradition, that's how it works. Look at TV shows. But moreover, even if you say strike that sentence or anything else, it's not enough. It's remembered by the judge and the jury. It many times still can bring the memory to that witness. Why on our side it's not the same? Because when the judge asks questions the witness, when he directs the entire investigation, this is where he wants to get the truth. We don't think that judges care so much if they're unfaithful or not, etc. They're likely to get to the truth. That means that their incentive is not to bring the most powerful memory. That means that when a sexual assault victim is there, he wants to get the truth. He wants to make sure that she was actually sexually assaulted, but he doesn't want to make her feel like he doesn't believe in her or anything like that. Why is it crucial? Firstly, just more justice. But moreover, we actually don't harm sexual assaults. And lastly, witnesses come forward. If I know that it's going to be a humiliating process in court, I'm less likely to go to the police to report a murder or anything I saw. I'm less likely to go to court of that. I call you to oppose.
Extension in terms of what we have to accomplish, and then answer the two crucial questions that the opposition teams have asked. Why is CG's framing more important than that of OG's? And I want you to note this clearly. Okay. OG hang their hat on the incentive of these courts that they profess on their side, and particularly on the framings of how the Supreme Court abstracts the decisions around this. Philip directly contests this by pointing out the incentives and the capacities of the local courts when they interact with civil law cases, as well as with criminal court cases, in terms of how precedent setting is more immediate over there. I will describe this in just a little bit more detail when I'm engaging with OO. But more important, the whole idea about the matter of redress that the APM talks about in terms of the challenging of the decision is something that Philip crucially fills in the MEC for when he talks about that this redress is specifically reliant upon the challenge and the reinterpretation of the precedent on the specificity of the law being discussed and how that spirit of the law necessarily needs to be applicable to the individuals. Here's the one thing that needs to be understood by everyone in this room. The law usually ends up lagging behind the individual's preferences, the trends of technology, and usually how people interact with society in and of itself as well. The German law system is a clear example of this, where the GDPR essentially took about 15 more years to even catch up to what digital theft, what privacy laws, what cookies and settings and everything else that associated themselves with it was supposed to be. Again, when I answer opening opposition over here a bit more, I will go into this, but the MECs for there are already present in Philip's speech. Closing opposition crucially asks, what does the spirit of the Constitution or the spirit of the nation necessarily mean here? We essentially talk about what the law's applicability in terms of the Constitution ought to be when these crucially nuanced cases are being discussed here. Because note, this debate is not about the cut and dry cases where both sides are outlawing certain things. This case is specifically about the gray area of criminal laws or civil laws on specific issues on environmental policy or technological policy where the judges and the courts and the Constitution and the legislature doesn't have the specificity of the words. Let's bring in opening opposition into this debate now. I will answer them on two fronts. Number one, on how the legislature process has a higher bar for actually being able to address all of these things. Because opening opposition hangs their hat on the idea that the legislature can address everything and thus is more representative. A, this relies on the idea that the addressing of these issues happens in a manner that the timely passing of these laws necessarily addresses the miscarriages of justice in various civil law cases or criminal law cases that they can be addressed. Here's why that doesn't happen. Because a legislature has to address the law in its abstraction with the specificity of the cases in terms of whether they can actually be passed. The law usually has various clauses, sub-clauses, and then specific words that need to be individually addressed, particularly with really detailed constitutions like that of Japan and Germany. Specific clauses have to be really detailed and individually addressed in order for the legislator to be able to pass through. This is particularly why when they're discussed in the parliament, even when the incentive for passing those laws is in place, they're often shut down by opposition, or because the specificity of the words and the clauses is not specifically redressed in the Constitution in and of itself, they don't pass through. Secondly, opening opposition don't really take into account that even if the people prefer something to be passed, the legislature and the representatives who are present in the parliament might not just pass those laws because of specific political incentives, because of handshaking between different political parties, or because of different political incentives that may exist. So that capacity and incentive is not discussed on their side as well. So what's the mechanism in terms of immediacy on our side that Philip explains to you? Basically, the courts, the local high courts and the local criminal courts who are basically discussing the precedents on specific individual applications of law are able to address these reinterpretations on a more immediate basis. Why? Because they have the capacity to be able to write out individual rulings that specifically apply to those cases in those specific instances and set them as precedents. These are specific things that are not available to the courts in the opposition side. That specifically means that the individuals who are suffering from a particular miscarriage of justice or who want something redressed are able to have those cases heard a lot quicker on CG's side on those specific mechanisms rather than on opening opposition side, because you need to wait for the legislature to vote in your favor. You need to ensure that the politicization is going to be favorable on that front, and then you need to hope that the parliamentary discussion around the specific clauses of the laws, around the redress of the laws, everything else basically pans out in your favor. All of those individual instantiations become much more accessible on CG's side.
Philip explains this to you. Before that,
At best, this is a very short-term harm where a couple of nuances sneak under the radar, and then politicians realize, oops, we don't have a law.
No.
The law.
The legislative changes takes about an election cycle of about 4 to 5 years. After that, the writing of the law takes even more time with more money and resources guaranteed. It can take a decade on the average number of cases. I think you're underestimating the extent of that. Then, Philip also explains to you why the advocacy nature of individuals being able to argue for you is particularly important in the context of these laws and these court systems as well. And this is where we also engage with CO now. Because here, crucially, CO hang their hat on the idea that the judges are going to be rational and neutral observers enough to the degree that the decisions are going to be well-meaning. If they're claiming that the police have a bias, then they can't simultaneously claim that the judges don't have a similar amount of bias on their side, given the interaction argument has basically been redressed on the idea that it doesn't necessarily happen. But more importantly, they don't address the idea that the judges usually address the letter of the law, bearing in mind the experience that they've had, bearing the amount of desensitization to the number of cases that they've had, bearing the amount of malpractice allegations that they can be subjected to if they don't follow the letter of the law, in line with the Constitution. On our side, specifically, we're able to uphold the principle because the individual who needs to have the legal representation that they need, because most individuals don't have adequate understanding to be able to interpret the law in their favor, have those defenders who can argue for them, where the judges are minimally interventionist and then have to look at how the application, but more importantly, how the spirit of the law needs to apply in the application of those nuanced cases. Not in the cut and dry cases, in those nuanced cases where this specifically applies, which means for both OO and CO, we're able to get that immediate redress a lot more quicker. The legislation passing might happen in a number of years. The judges might not be biased, but that interpretative weighing on either side of the case is more immediate on our side, which then forms the basis for any kind of presidential hearing as well. CG.
I am truly confused by the stance given to you by governments. Governments say, look, the court can influence your entire life. They can make or break your ability to have the most basic human rights. And therefore, what we want the court to have is zero ability to ask questions that are going to help the court actually making those decisions. If somebody would have need to decide whether they're going to kill me or not, I would want them to make sure that they have all of the answers that they need in order to make their decision. Notice at the most basic level what governments support. They say they are going to make a decision whether to kill you or not, but if they are not sure if you are even guilty, they have nothing to do with that. They need to make their decision based on the facts given to them with no nuance like CG wants and without any ability to investigate further. This is just ludicrous, and I beg you, panel, to never trust your life with somebody that can't ask questions, kind of like you're doing right now. I'm going to have 2 points in my speech. First of all, I'm going to talk about discovering the truth and kind of like remind each other why we have court from the get-go, and then I'm going to talk about better experience. But before that, let's just tackle everything else in this debate. I'm going to start with like democracy and rules, etc., etc. Unfortunately, I think that many of the cases coming from CG is kind of close to OG, so responses will be close. Opening government says, look, it takes a lot of time to actually change legislation. Notice that I'm truly not sure why that's the case. Maybe for, I don't know, constitution it's very hard, but many legislation passes every day assertion. But let's assume that they are right and every law is very hard to pass. We say in the POI notice, this is a feature, not a bug. What does it mean? Because notice what OG themselves say. When you make a vote under election, you not only influence yourself, but you influence your entire country. This is exactly why we make it hard to change the legislation. I'm talking from the bottom of my heart, panel, when I say that we just had that case in Israel. Majority voted in favor of changing the entire jurisdiction system. If changing laws were that easy, Israel today would have been already an autocracy. But the fact that it takes a lot of time, the fact that you actually need to make majority of vote, this is exactly what actually makes laws better, because you negotiate, you make sure that even those that don't want to vote now can vote for it later. We think it's a good thing, and they never analyze why having a long process is equal to a bad thing. assertion completely. Then they say, oh, it's critical for us to take care of minorities on their outside. And I'm sorry, panel, but let's just get out of debate land and not be as left-wing as OG was in that specific case, right? Just because somebody studied in Harvard or in Yale does not mean that the thing that they care about is minorities, right? Just because I'm a white male does not mean that I care about women. You know how I know that? Because 12 white male just voted against my ability to decide that I don't want to get a fucking child out of my vagina, right? Which I think is kind of basic. Open opposition, though, we think doesn't actually deal with some of the claims coming from OG, right? They never deal with the fact that OG says, oh, well, maybe they are not the best, but we need some sort of criticism in order to have some sort of balance. And then they say, oh, look, politicians are the ones that actually choose the judges, so in some cases it's going to be good. This is exactly how we enter this debate. Because notice that in order to have criticism and in order to have those checks and balances, you need to have a full picture in order to create a change. If you don't have a full picture, your ability to create a good change, like OG themselves claim that is the goal under their case, is not there. You only get a full picture and a full truth if you have the ability to ask the question as a judge on the missing parts of your case. Second of all, notice that your ability to create change depends on minorities actually coming to the court and actually wanting to create a change. What Boris claimed in his speech is because of the way that we treat minorities today in court. The fact that a woman that was raped is so scared to get to court because the defender is going to claim that she wore something that's too short or she wanted to be raped. This is exactly the things that are now making women fear. Therefore, we don't even get the cases in front of the court because of the victims afraid to approach that. So we think that priority logic in order to create the crucial changes that OG wants is to have those cases. This is exactly how we win this debate. Just one couple of points of external rebuttal. About predictability by opening government, the fact that now you're going to have more investment in the developing world. I think that if you just don't change the rule every day by having President's Day being made every day, then more investors want to come into your country because they know that they can have factories for a long time. And let's tackle a couple of things from CG. The fact that you can call it out if there's something biased. You know how you can call out if a judge is not going to ask a woman how she felt or what happened, then it's easier to say that he was biased against that specific woman, therefore we get it more under outside the house. And then they say, look, the government has a lot of power and now we're going to have the ability now we're talking about the gray area and about the big things. Notice that just assertion, we have a lot of things coming to court, we think that with outside it's even better. And notice that we win also those things anyway. Let's talk about discovering the truth. And you know what, before I talk about that, let's take over.
Yeah, so surely the reason why victims are uncomfortable coming forward is because of things like cross-examination, which occur on either side. On your side,
no, but now when there's cross-examination, the judge can say, you are fucking being rude, I'm going to take it over from here and change the way that that victim feels, which you don't get under your side of the house. Discovering the truth. Because notice, as Buzz already said, the main reason why we have court is to actually find out more things. This is why as a society, we rather having people that are maybe guilty being issued out in order to make sure that we have as much of the truth as possible. Notice where we have it more, because opening government says, oh, but some judges are going to have more feeling towards one side than the other. But notice that all those things are symmetrical, because you can have juries that are going to balance some of those biases out. But the question is when we have the ability to find out where somebody was in day A and not B, and information that you don't have under their side of the house. Why is that? Because today lawyers want to only bring their narrative and their side, the things that are actually going to support what they want to do. But what they want to do is not necessarily the truth. Why is it crucial? Because we think that once you discover the truth, this is where you have more trust in the system, like OG themselves claim that they want. When you have more of the truth, this is when the criticism is actually accurate and can create change. When you have more truth, it means that the equality is not just by who has a better lawyer, right? But the equality is about the rights that we are taking care of when we make the decision. We think that knowing the truth and having more cases is the prior logical thing to everything else in this debate. For all those reasons,